Good afternoon, everyone, and thank you for joining the Collateral Consequences of a Juvenile Adjudication webinar, How Juvenile Records Can Affect Youth Even After the Case is Over. My name is Chidi Umez, Project Manager for the Criminal Records Project with the Council of State Governments Justice Center. The Council of State Governments Justice Center provides practical, nonpartisan, research-driven strategies and tools to increase public safety and strengthen communities. Before getting started, I'd like to briefly talk through a couple of housekeeping items about how the webinar is going to work. Anytime during this webinar, you can ask a question by typing it into the Q&A panel on the bottom right-hand portion of your screen. This includes both technical and content-related questions. We will try to reply to the technical questions in the chat window as we go. For the content-related questions, we will keep a running list and address them all at the end of the webinar. We'll do our best to get through as many questions as possible. If you do encounter technical or audio problems during this webinar, please call WebEx Technical Support at 1-866-229-3239. That's 1-866-229-3239. Please understand that there are some technical issues we may not be able to resolve. For this reason, we are recording the content portion of this webinar and will post it on the Clean Slate Clearinghouse website. We should have the webinar posted online in the coming weeks. We're happy to have as our presenter today, Serena Holthe, Special Counsel with the National Juvenile Defender Center. You'll hear from her in a few minutes. This webinar is part of the Clean Slate Clearinghouse, a project funded by the U.S. Department of Labor and U.S. Department of Justice. The Clean Slate Clearinghouse was created to support juvenile and adult criminal record clearance around the country by providing up-to-date information on record clearance as well as contact information for legal service providers in all U.S. states and territories. The Clearinghouse provides tools and resources for legal service providers currently engaged in record clearance work or those who want to expand their record clearance services. The Clearinghouse also provides information to compare record clearance policies across jurisdictions and to learn about best practices. The site was designed to capture three target audience groups, the first being people with criminal records who are seeking to have their record cleared. The second are legal service providers who offer record clearance services. And the third being policymakers who want to compare record clearance policies across the country. Within these groups, however, we also anticipate that the site will be used by reentry and workforce service providers who can connect people to legal services, by indigent defense attorneys or pro bono attorneys who are interested in starting or expanding their record clearance practice, by researchers or journalists who want to compare trends in record clearance legislation across the country. We encourage you to visit the site and sign up to our newsletter to receive information regarding resources, future trainings such as this one. And now I will turn it over to Serena.
Thank you so much for joining us today. I have to first apologize that I have a cold, so I sound a little hoarse and I might end up needing to cough a little bit in between, so please bear with me. I am really excited about this topic, and I'm really excited to share information with you today. First, let me tell you a little bit about the National Juvenile Defender Center. We are a nonprofit, nonpartisan organization dedicated to promoting justice for all children by ensuring excellence in juvenile defense. Through community building, training, and policy reform, we provide national leadership on juvenile defense issues with a focus on curbing the deprivation of young people's rights in the court system. Our reach extends to urban, suburban, rural, and tribal areas where we elevate the voices of youth, families, and defenders to create positive case outcomes and meaningful opportunities for children. We also work with broad coalitions to ensure that the reform of, of juvenile courts includes the protection of children's rights, particularly the right to counsel. And I focus on post-disposition matters, which means any time after disposition. And similar to adult court, it's called sentencing. In juvenile court, we generally use the term disposition. And collateral consequences and record clearance are really important to understand as we are dealing with young people in the juvenile court system. And I wanted to talk a little bit further and get into some more details with you. But first, I would like to ask a few polling questions. So please let me know your answers. How would you describe your place of employment? As a probation department, juvenile court personnel, law enforcement, community service organization, civil legal aid attorney, prosecutor, juvenile defender, or other. The poll is open and it's on your right-hand side of your screen. Please let us know how you would describe your place of employment. We're going to leave that open for a couple more seconds to give people an opportunity to respond. And as soon as we've had some more responses, we will then end the poll and show you the results. Okay, so we have actually several people who are from probation departments, a couple of juvenile court personnel, a couple of law enforcement, community service organizations, civil legal aid attorneys, prosecutors, defenders, and a lot of others. I wish I had done better so I could figure out who are the others, but thank you all for participating. It's good for me to know who is on the webinar so I know who I'm talking to and can be prepared to address remarks that might be applicable to you. So our next question is a polling question. Have you attended any NJDC trainings, accessed NJDC resources, or contacted NJDC for assistance? Choose A if this is the first time, B once or twice before, C a couple times a year, or D frequently. This is our chance in trying to figure out how good a job we've done in reaching out to the community. We are definitely here as a resource for juvenile defenders, but we also want to make sure that we are reaching out to others who are involved in trying to make better outcomes for young people through the juvenile court system. So that poll has ended, and in just a second, it will show us all the results. And for most of you, this is the first time. A couple times, or actually several, once or twice a year, a couple times a year, and a few frequently. So the third question, polling question, is how long have you been involved with the juvenile court system or youth from the juvenile court system? This helps me understand a little bit more about the audience. Also, answers being 1 to 2 years, 3 to 5 years, 5 to 9 years, or over 10 years. And most of you fall into the first or the last category, 1 to 2 years or over 10 years. And the final polling question is how many states keep all juvenile records confidential? This is really getting at the substance of our conversation for today. So what is your best guess? How many states keep all of their juvenile records confidential? Not by confidential, I mean not available to the public. Is the answer 3, 8, 19, 24, or 31? Sometimes I ask this question in the reverse, and how many states have all their records as public, but this time I thought I would just ask it as confidential. So we had a wide variety of answers here. Basically, almost everybody has, every category had about the same number of answers picked. The correct answer for that one is actually B, 8. Most states actually have at least some juvenile records that are open and available to the public. Which kind of gets to our subject of the juvenile record collateral consequences. So there are so many common misunderstandings in the country. I have traveled from the East Coast to the West Coast and the Midwest, from the North to the South, and everywhere throughout the country, most people believe that their juvenile record will just disappear when they turn 18, that they won't have to tell anyone about their juvenile record, or that no one will ever find out about my juvenile record. And in most states, that's actually not true. There are many ways in which a juvenile record can cause problems for a young person well after the case is over, well after the young person's turned 18. And that's what we're going to talk about today. The first thing is records, public versus confidential. So there are about 6 states that keep all juvenile records open and available to the public. And by all juvenile records, I don't necessarily mean the social records. They're the things such as a psychosocial evaluation, the probation officer's filings with the court. Those things I'm not necessarily referring to, but what I'm referring to are the charging documents, any orders signed by the court, things of those nature that really just describes what happened in the matter what the young person was charged with, what happened, whether the young person adjudicated, what probation terms, whether the young person had a violation of probation, things like that. So on the flip side, there's only 8 states that actually keep all juvenile records confidential. And by keeping those records confidential, there is a varying level, but in this way, I'm really just meaning not available to the public. Almost every single state allows for sharing with schools, obviously sharing with court personnel such as prosecutors and defense attorneys. There's also some states that are sharing information with the FBI, and all of that can affect whether it's public, whether it's confidential, who's it shared with, can affect the long-term consequences for a young person. Now, the police records don't always follow the same line as the court records. So the court records could be confidential, but police records are available to the public. They don't always coordinate with one another. Every state has different laws for these. And also there are times where police records may be shared with FBI where court records would not be. And in police records are oftentimes fingerprint records or DNA records. And these are ways that even if a juvenile court record is confidential, there could be times and ways that fingerprint records or DNA records get into a database that ultimately gets shared with the FBI. And then if somebody runs an FBI background check, those things show up, even if they are juvenile adjudications. And the one caveat I need to mention is that even if the records get sealed, expunged, deleted, destroyed, whatever the term is for record clearance in your state, that if the information has been sent to the FBI does not have any obligation to actually clear that record, and most of the time that record will still be showing up anytime an FBI background check is ran. There's also DMV records, or whatever you call your Department of Motor Vehicles Administration, whatever it's called. Oftentimes there are records related to the juvenile court case that are shared with that entity. And there are times and certain states allow access to that information by insurance companies or employers to understand what the person's driving record is, and that could include information about a young person's juvenile record. So all of that, records being created, also ends up affecting employment and a young person's ability to gain employment. If an employer is able to ask a question about a juvenile adjudication on an application, if the employer asks questions in interviews about a juvenile adjudication, or if the background check shows up information about juvenile records, that could end up with the young person being denied employment. Some states do have laws that shield and require employers not to use that information to deny a young person employment. However, that's really hard to enforce. And also, many employers don't even understand that what they've gotten information on is actually a juvenile record and not an adult criminal record. There's usually nothing in any background check information that highlights the fact that it was a juvenile adjudication and not a criminal conviction. And so therefore, employers oftentimes are mistakenly reading these documents and seeing things and interpreting them different. There's also when a young person's driver's license is suspended for their juvenile case, then the driver's license suspension could end up being a hurdle to employment. The young person might not, many young people who are out there looking for jobs might often be looking for a job that's related to driving. They can be a valet, or it might be a delivery job or something like that, and not being able to have their driver's license could be a problem and being able to obtain that employment. And many states do have professional or occupational license exclusions, meaning that a young person with a juvenile record may be denied a professional or occupational license because of their juvenile record. That is not in every state. In some states, that hurdle can go away if the young person's record has been sealed or expunged or whatever else you want to call the record clearance process. But it definitely does vary by state. And for a young person, sometimes they have been able to get into a trade school and have borrowed money to attend this school, and then at the end, they find out that they're not even eligible to get the license in order to practice whatever it was they went to school for because of their juvenile record, causing many more financial issues for that young person. There's also many hurdles related to education. So many young people who have been involved in the juvenile court system are faced with hurdles getting back into school. So if a young person happens to have been in a placement or otherwise outside of school for a period of time, re-entering their local school can be a problem. Some states have laws that talk about and require immediate re-enrollment. The ESSA, recent federal statute law that was passed, that requires schools and every local school district to have a plan on how they're going to get young people back into school as soon as possible after being released from an out-of-home placement. I don't know how good everyone's plans are, but that is a place to go to find out what your local school's requirement is. But also understanding that the school, you know, we've had clients where a young person was released from a facility in January, and the young person was told by their school, oh, you can come back in August. That's probably the best time. You just missed too much school anyway, and it's just going to work better that way. But can you imagine, what is a 16-year-old going to do from January to August that's going to definitely include them not getting into trouble? That'd be hard for anyone to not get into trouble in that time without anything productive to do. So it definitely can be a hurdle to the young person's success. Even if they're on probation, it can probably cause many problems with their probation order and being able to comply with what the judge has ordered in that case. Even states where it says the young person must be immediately re-enrolled, there are oftentimes re-enrollment requirements that, you know, people generally don't even understand. They have to make a meeting with a certain individual from the school, and they have to go to that meeting, and that person might not be available for the next week to hold this meeting, and then all these other things need to happen. So immediately, as in the statute might be described, might not actual and reality mean immediately. Young people who have been in out-of-home placements oftentimes have problems getting credit transferred back to their local school when they go back to school. This can cause numerous problems for the young person. If the young person has been taking classes and attending and doing what they were supposed to do in their out-of-home placement, and then when they get back to their local school and now they don't get to stay in the same grade, they have to go back and be in a lower grade, or they have to repeat classes that they may have already taken, that young person could get really feeling defeated in that process, that they already had done this, and why isn't it good enough that it had already been done? Some schools have problems calculating credits for partial semesters. So a young person might only be in an out-of-home placement for 2 months, but they took classes and they stayed up with things during that 2 months. However, because their local school doesn't have a way to process that, it's very difficult sometimes, and the school oftentimes will then deny the young person a full credit for the work they had done while they were at placement. And if the young person is feeling defeated that they've done what they were supposed to do and they constantly are hitting these barriers, the young person might ultimately end up dropping out of school because it's harder and harder for them to get back into school, get the credits, stay with their same classmates, not being treated different just because they had been involved in the juvenile court system. There's also school discipline. So many young people who have been involved in the juvenile court system have been targeted for school discipline. So now they are now considered the bad kids. And so people had their eyes open and their ears peaked to hear and think of when that young person might cause quote-unquote trouble. And then now that young person is singled out for school discipline. And as many of us probably know, that young people who are involved in the juvenile court system have a higher rate of special education needs, and many of those needs are not met, whether it's by the juvenile court system or otherwise, by their local public school. And so many times a young person's acting out or having problems might be a result of their special education, but it ends up becoming a school discipline issue instead of addressing it through their special education needs. And also a young person ends up missing many days of school because of their juvenile court involvement. There may be hearings, there may be times where the young person needs to meet with their attorney, probation may need to meet with the young person, things like that that could really disrupt a young person's education. There's also this thing called the Common App for College. So this is an application that is accepted by over 600 universities and colleges throughout the country, and the application itself asks this question: have you ever been adjudicated guilty or convicted of a misdemeanor or felony? Now, stop right there. I would probably advise a young person to say no, because we don't call it guilty, we don't call it convictions. However, there's actually some explanatory material along with the application that says adjudicated guilty also means adjudicated as a juvenile delinquent. So this includes delinquency adjudications. It goes on to say, note that you are not required to answer yes to this question or provide an explanation if the criminal adjudication or conviction has been expunged, sealed, annulled, pardoned, destroyed, erased, impounded, or otherwise required by law or ordered by a court to be kept confidential. So this is where it gets really confusing. So first of all, like most of us as even heavily involved in juvenile court proceedings, this is a confusing question, and how do we expect young people to be able to really thoroughly think this through and understand the answer? I don't know. It's complicated. We do know from the explanatory material it's asking about juvenile adjudications, but it gives the young person an opportunity to say no if their record's been cleared, or if it's otherwise required by law or by a court order that that young person's record is to be kept confidential. So in most states, there's some records that are confidential and some records that are available to the public. But unless the young person actually knows what records are which, whether their record falls under the confidential one or their record falls under the public one, they won't know exactly how to accurately answer this question. And it can be pretty darn confusing for even me as an attorney to figure out whether a particular adjudication would fall underneath the need to disclose or whether you could actually answer no to that question. So there's also a lot of housing hurdles that someone with a juvenile record may have to overcome. So there could be a denial of housing. And in regards to anytime a juvenile record is made available to the public, landlords could be able to access this information on a background check. Public housing authorities have asked questions related to juvenile adjudications on their applications. There is a way that things can be disclosed and discovered by the private landlords or public housing authorities. Now, there are federal regulations that require there to be two types of offenses for which someone cannot live in public housing for their entire life. They have a lifelong ban from being able to live in public housing. Those two things include a conviction for making methamphetamine on public housing property, and if the person has to register as a sex offender for life. Those are the two areas in which someone can be banned from public housing for life. There are other areas in which the federal government allows local housing authorities to limit the people that they accept or whether they are going to evict someone based upon their drug or violent offense, whether it took place on the property or not. So a young person who got in trouble, whether it was on the public housing property or not, if related to drugs or violence, it could potentially become a problem for that young person or that young person's family to be able to continue to live in public housing. Many times it's become a bigger and bigger issue that young people are becoming homeless. There is several clients that I can tell you their stories, but one young person that I know of was released from a facility, and the reentry plan, I will say the quote-unquote reentry plan, was for that young person to be taken from the facility to a homeless shelter. I do have to say, question that someone actually took the time to really look into that and make sure that that was a good reentry plan. But reentry planning should happen early. Should not wait until the end so that that might be your only option. We've got to start thinking about where is this young person going to go after release? Because you know what? The young person's not always able to go home. The young person might not be allowed to go home because of mom, because of dad, because of their adjudication, because of anything that's going on. Lots of circumstances could happen that could cause a problem there. And so anyone who's responsible for helping reentry planning, please make sure it gets started early, because at this point we are releasing more and more kids into homelessness. There was a recent report released by Chapin Hall that indicated in the young people that they interviewed, almost half of them had some sort of involvement with the juvenile court system. That is atrocious. It is not, the report is not indicating that the juvenile court system caused the homelessness, but the fact that all of those young people had contact with, that means that we need to make sure that we are providing better services and understanding how to make sure that our young people are exiting the system with the resources and abilities to overcome any problems that might end up with the young person being homeless. There are also many other collateral consequences. So there are sentencing enhancements. whether it is in juvenile court or adult court, a young person might, their juvenile record might be something that the judge can access and look at to determine what kind of sentence a young person should get in their following juvenile case or an adult criminal case. Sometimes it can even be looked at in determining bail or determining pre-trial release conditions. And then also public benefits. If a young person happens to be placed in a secure facility, not just any facility, but a secure facility, then their benefits could be cut off. So the SSI, the supplemental security income that the family gets for that young person, the food stamps, the TANF, the Medicaid could be cut off for that young person when they are in a secure juvenile facility. And being able to get that young person's benefits reinstated immediately upon release are extremely important, especially in courts when the court has required the young person to maybe continue with mental health care or drug treatment or things like that for which they're going to need their Medicaid, for which their family is going to need to have the food stamps reinstated for the young person, so when they're coming back to the house, they have that for them. There are sex offender registration requirements in many states that will require a young person to register, whether it be for a period of time or for life. These registration requirements can vary from a private list to a public list. Some states, such as South Carolina, and South Carolina doesn't treat juvenile sex offenses any different than adults. And so a young person could be required to register on a public sex offender registry for the rest of his or her life. There's also fees, fines, and restitution. So if a young person is unable to pay some of their fees, fines, or restitution, it could, number one, end up with that young person not being able to successfully complete probation. Not being able to successfully complete probation can cause many problems. You could have a violation of probation, or you could just be, quote unquote, unsuccessfully completed in your probation. And that could also lead to problems when a young person would like to clear their record. Many states do not allow a young person to clear their record if they unsuccessfully completed probation. So this is one way in which a young person's inability to pay a fine, a fee, or their restitution as a young person, when they become an adult, that it becomes major hurdles for them. And even while they're a young person, while they're still under the age of 18 or whatever the age of adulthood is in your state, that it can still cause many problems. Just because a young person doesn't have the finances and ability to pay the fees, fines, or restitution, it really becomes a hurdle to whether they can clear their record in the future, whether they get a violation of probation, which could mean that young person is eligible to be placed in an out-of-home placement. So I think we've got to think about fees, fines, and restitution from the beginning of the case, but also on the back end of a case and how we can help a young person address these things. They also can show up in many states, and they're reported to credit reporting agencies. And so when somebody runs a credit background check on a young person, and many jobs these days are actually doing that, and landlords oftentimes do that, that it could show up as being an unpaid debt on their credit report. There are numerous immigration consequences, and the consequences are very complicated. This is definitely an area where I would suggest if there's any questions to address them to an immigration specialist. They are complicated. There are definitely some areas in which I could use some more education, but I think that we need to make sure that we utilize our experts in this field to help us understand. But just know that a juvenile record can also be a hurdle for a young person in any immigration proceedings. The military, the United States military, and for a young person to be able to enlist in the military, So the military does not actually consider juvenile records any different than adult records. They equate both. So whether it's a juvenile adjudication or an adult conviction, if it's for a felony, anything involving drugs, domestic violence, those things you would have to actually get a waiver in order to be allowed to enlist into the military. Now, each branch has their own specific requirements and their own things in which they're willing to waive, and certain things come into consideration for waiver. Sometimes it could be that if your juvenile record is preventing you from lawfully carrying or owning a firearm, then that could actually prevent you from being able to join the military at all. A domestic violence adjudication or conviction that would limit your the young person's ability to carry a firearm would also limit the person's military service. But things that had nothing to do with anything like that could end up being a problem and a hurdle for the young person to be able to join the military. So through all of this, I hope that we have addressed and helped you realize and see that there are many consequences to a juvenile adjudication. Now, I haven't been able to tell you specifically in your states what the law is because it definitely does vary by state. You know, California, there are certain serious offenses that are available to the public that it's a long list. I actually just recently went through it, and it's a really long list of offenses that are eligible to be made public. And in the state of Nebraska, all juvenile records are available to the public. Then we have states like Maryland. Maryland does not actually have any open juvenile records. They also have a law that prevents the juvenile record information from being shared with the FBI. And therefore, it's only limited sharing that Maryland actually allows, which really helps to protect juvenile records and a young person to have fewer hurdles as they're trying to succeed in adulthood. Now, I will actually take some questions if you guys happen to have any questions now, and if there's anything that you would like to know in regards to juvenile adjudications or juvenile collateral consequences to juvenile court involvement. How can we get state-specific information regarding confidentiality of records? The state laws are constantly changing right now. It is potentially an issue that there's not anything that's current available online. What we are doing at NJDC is we are creating booklets, collateral consequences checklists or booklets that are going to help delve into that issue for each state. By early on next year, we will have available to California, Nebraska, Washington, Missouri, South Carolina, and Maryland booklets that describe these consequences in each state, including the confidentiality. But there's also on our website, which will actually be on our last slide here, that website includes the rest of the checklists and booklets that have been created by other entities for various states around the country. Is there anywhere I can see state by state what the different disclosure legislation is? Similar question, I guess, about the confidentiality and where to go to get the information. Do you know what states legislate that employers are not allowed to ask the question about juvenile adjudications? I know that California has a statute that specifically says that employers are not allowed to ask about juvenile adjudications, and if somehow they are revealed that the employer is not supposed to take it into consideration, that last part is a little difficult to actually enforce, but that is the law. Is anyone working in the area of getting expunged records removed from FBI databases? So I think that is definitely a federal law issue, and to getting the federal government to honor state expunging records, I think, is a great endeavor. State level, it kind of honors what the state has determined to be appropriate when to clear a record. But I don't know of anyone that's actually made that something for them. Are there efforts to remove the question on the common application? So yes, there is a group of folks that are working with the common application folks in regards to changing and or completely eliminating the question. Many colleges or universities are worried about some sort of liability that might attach by having young people or having folks with records. And so that's generally been the pushback that we've heard from them. So we've been really trying to encourage young people, if you feel like your record may be used against you in some sort of way by having to answer the question on the Common App, you can go to that individual university or college's application itself, and it might not ask that question. Not all of the colleges and universities who use the Common App have questions on their own application that would include a requirement to disclose a juvenile record. Can DNA be obtained for juveniles? So the state on when DNA is actually taken for young people varies by state. So, for example, in South Carolina, DNA is actually taken and it's put into a database for that could potentially be shared. The record that goes along with fingerprints or DNA actually indicates what the young person was arrested for, all their personal identifying information, such as the name, date of birth, race, gender, things like that. And it doesn't always include the outcome of the case. So, you know, there could be some definite hurdles in regards to what is being shared in the DNA record or in the DNA record or in the fingerprint record. So I'm going to move on into the next part of the presentation. I'm going to go back and take some more questions at the end, but I want to continue on to kind of talk about how can youth overcome these barriers and what can we do as practitioners to help them overcome these barriers. One of the biggest things is actually record clearance. So record clearance in most states will help address many of these issues, whether it's called sealing or expungement or expunction or destruction or deletion or vacating or erasing. In many of those areas, the record clearance may actually erase many of the hurdles that we've just talked about. And this Clean Slate Clearinghouse website is actually a place for you to go to see what the rules or what the statutes are in your area. So here is a screenshot from Missouri. And as you can see here, in the Learn About Your State for Missouri on the Clean Slate Clearinghouse website, you see that there's adult criminal records and juvenile records. When you select the juvenile records option, here comes up the overview of the record clearance in the state of Missouri. Most juvenile records can be sealed after you turn 17 or when your case closes, whichever occurs last. You have to submit a request to the court to start the process, and it is up to the judge whether or not to grant your request. So that is, I picked Missouri because they tend to have actually a fairly simple statute, so it didn't get into many different details. In some of the states, like Colorado, there are many, many, many different requirements and aspects to record clearance that the list is much, much longer than this. But just to give you an example, this is where you can go to get the general information about juvenile record clearance in the state. Now, that's not too specific, and it doesn't give you all the details about how to do it, But one of the best things we have included in here is a Find a Lawyer page. And the Find a Lawyer page actually helps, it provides contact information for different legal service entities in your state that can help address, answer questions, possibly even take on a record clearance matter on behalf of the young person so that their record could get cleared. So the site also does include court forms and resources. So if your state has a template petition to seal or expunge or delete their records, or other resources that will help understand the process and issues related to record clearance in your state. Those are also links that you will find here on this page on the left side. And then under for attorneys along the left side, it says legal policies and statutes. So that's where you get into the very detailed aspect of what the requirements are for record clearance. So it goes into the eligibility. Who can get their juvenile record cleared, whether it's by offenses, whether it's by ages. There's many different requirements, and it varies very much by state. You have Nebraska that you just have to have successfully completed probation, and then you can ask the court to seal your record. You have California that actually has some automatic sealing for certain cases. If a young person has successfully completed probation, they don't have to petition. The court is supposed to automatically seal their record, and other times, if that didn't happen, a young person can later petition to get their juvenile record sealed. Are there exceptions to eligibility? So many states say you can get your juvenile record cleared except for in these certain serious offenses, or you have to wait, and what is the waiting period? So there's times that you might have to wait 3 years or until you turn 21 or 18 until you're able to be able to clear a record. And then is there whether there's a fee required. So many times there's actually fees that are required for filing a petition to get a juvenile record expunged. So in the state of South Carolina, it can cost $315 to get a young person's juvenile record expunged. And $315 is not waivable. There's money that is owed to the solicitor that has to be paid to the solicitor's office, which in South Carolina is the prosecutor, that pays for them to process an application, and then it goes to the court. Then there's states where it could cost maybe $30. So in Maryland, there is a $30 expungement fee. However, you can request to waive that fee, and many times if you can prove that you don't have the ability to pay the money, you can get the $30 fee waived. And in other states, it actually doesn't cost anything. All of this information is included on the website. There's also the effect. So what does record clearance actually mean? What does it actually do? So in some states, a juvenile record could be expunged, but it doesn't actually mean that it's deleted or erased or something like that. In some states, they use the word expungement, but it really is more like sealing, where they take it and then it is no longer available to the public, but it still exists and it's still available for certain, mind you, very few people, but certain people to actually still view. And then there are some states that if it's expunged, then that means that the Department of Juvenile Services or whatever the entity is called in your state might also have to delete, erase their records, or whether the prosecutor has to delete, erase their records. Any indication in public files of the juvenile record may need to be sealed, expunged, or whatever the requirement is. The website also will help you understand what legal service providers there are that can help you get their records cleared. And then there's also a comparison tool. So it will help you understand how certain states compare with others. One of the biggest things that we have seen a change in is that more and more states are allowing there to be an automatic process for record clearance. And so in that, we are actually have made that as an opportunity to be able to compare what states are providing an automatic record clearance process, what states don't, what does that mean, and it does vary. It might mean that it's automatically cleared at a certain age, or it automatically is cleared after a certain period of time, or it's automatically cleared after the young person has completed their case. So in different states, it works different. And also, we've also discovered that it is a little different in jurisdictions where a judge may decide this is how it's going to work in our jurisdiction, and it's still lawful within the bounds of the law that they seal the juvenile record at termination when the case is over, that it's going to get sealed so that it's no longer available except for a special court order that would unseal the record. So there are some states that by jurisdiction different things happen, and so it's very good to actually figure out what is occurring in your specific jurisdiction. But what else can we really do? Making sure that youth are connected to legal and social services is very, very important. To get help with employment, to get help with education, public benefits and housing, dealing with unpaid fees, fines, or restitution, and mentoring can make a big difference in a young person's life. These are all services that we highly recommend that young people are being connected to. The legal services in your area might actually include your local public defender office, local legal aid or legal services office, state protection and advocacy organizations, law school clinics, and disability rights organizations. All of these might be resources for the young person to help them overcome some of these hurdles to their success. And here is my contact information along with the information for our website that includes the Collateral Consequences booklets and other resources related to collateral consequences of juvenile court involvement. I'm going to go back and look at some of the questions you have all submitted and answer a few more of those. So feel free to submit more questions if you've had them. What is the largest or most prominent issue you are currently seeing of the issues you have discussed thus far? You know, I'd have to say education, that it has become a huge hurdle. One of the biggest indicators of success in life is actually completing their high school. And when we are creating more barriers and more problems for a young person to be able to get back into school or to get the services that he or she might need in school or to get the credits for which he or she is taking classes for elsewhere applied to their local school, I feel like we are really able to help a young person overcome these barriers when we address these issues. If the young person's able to attend school, stay, you know, in a positive environment, do what they need to be doing to succeed in life, that they will have better outcomes. And it is quite surprising. I would have to say that many people throughout the country don't think of this as being a problem. That getting back into school, or many states actually require that schools be notified if a young person is charged with a certain crime. And even at that point, the young person could be singled out for discipline, or the young person could have problems within the school because they've now been notified of their juvenile arrest or charge. And young people being able to be in school on a regular basis and have as few extra problems in that setting as possible, I think is really important. There's a question of, you spoke about young people enrolling in a trade school college program only to find later that they are not eligible to gain employment in a field based on their criminal background. How can a young person find out ahead of time if they have a record? So I do have to say that many young people actually have no idea what may or may not even show up on a record. I've asked numerous questions and gotten a variety of answers, whether they understand what they were charged with, whether they understand if they had an adjudication, whether they understand it was a pretrial diversion program, the confusion definitely does go on. And we at NJDC are trying to really make a change to that so that defenders are better equipped and able and ready to address these issues and make sure their clients fully understand these things. But all other juvenile court personnel, anyone involved in the juvenile court system, working with young people from the juvenile court system to help us help understand this process. Now, for states where juvenile records are only available to certain individuals, where they are confidential except for those individuals named, then it will be harder to actually access juvenile record information. But oftentimes, a local public defender office would be able to access that information. Many times the young person can access the information through the courthouse, getting the information from the clerk's office themselves, talking to the lawyer that represented them in juvenile court, many different ways to try to get at what the young person's record is. Also, there's many times a state depository of information. So in Washington, the state police keep all the information, and you can run a record. I think, I could be wrong, but I think it's $15. It might be more expensive than that now. But there might be a state entity that could help run that record to get in that information so that the young person can understand exactly what might show up and what exactly his or her record was and whether it might prevent them from being able to be licensed for a particular trade. Do colleges using Common Apps do record checks automatically? I would have to say it varies by every college. Some colleges will do a background check, but generally to do a background check, many would require a specific permission, especially if they're going to run a background check through the FBI. If they're just going to run a state-based background check, sometimes they don't need the explicit permission, depending on what access that they're allowed to gain. So the college's use of background checks is really varying. Some colleges don't check at all. Some colleges don't really care about that question. It just happens to be in the Common App, which is why I suggest if you're afraid, if your young person is afraid of actually getting denied admittance into college because of their juvenile record, then looking at the individual college or university that they want to attend at their actual application to see if it asks any questions about a juvenile record, so whether or not they would have to answer or disclose their juvenile record to a college would be important. Are there any scenarios where a youthful offender's records would be cleared automatically without them doing anything, meaning when judge sentences him, he puts in his ruling to clear after time served? Yes. So many times, so let me just make a statement here. Many states actually use the term youthful offender to mean a special program that is mostly targeted to young adults. So whatever your state's age of adulthood is, most states that's 18, but some states that is 17, and some states that's still 16 and hasn't yet changed. So whatever that age is, that group that's older than that oftentimes is considered youthful offender. So if your question is about young people, those who are still considered minors, so whether there is a young person's record, any scenarios where a minor's record would be cleared automatically, the answer is yes. There's many states that allow there to be automatic. So in Washington State and California, there are automatic procedures to get that young person's record cleared without them having to actually do anything. And the website, the Clean Slate Clearinghouse website, is definitely helpful in the compare the states option to figure out which states are doing that, and exactly when you get into a particular state's information, you'll find out exactly when it happened. Because it could happen right after the case is closed, but it could happen 2 years later as long as the young person hasn't gotten another offense on their record, or it could happen at a certain age. It really does vary by state what these laws are, but I can give you generally state information, state-level information. So there are, have I answered, what is the purpose of the Clean Slate Clearinghouse effort? The Clean Slate Clearinghouse effort is to really help make sure that everybody understands what the record clearance process is in every state and jurisdiction. So we also include the 50 states, but also 6 territories, and what that means. So we want to make sure that there's information accessible to young people. So in that information I showed to you on that slide from Missouri, we tried to write that information in as simple language as possible so that young people would be able to understand it and know what generally could be eligible for record clearance in their state. Ultimately, we hope that they'll also go find a lawyer that would be able to assist them to understand whether their specific record would be eligible. Like I said, many young people are confused exactly about what their record might be. So really the first step would be to find out what the record really is, and there are many ways that we just discussed about how to do that. So I think that you can use the Clean Slate Clearinghouse to make sure that the young people you work with understand the process, that you as a court actor, personnel, or someone who's involved with juvenile court, with youth in juvenile court, that you also understand. I've heard many people say, oh, well, so-and-so told me that it wasn't going to cause any problems, it being their juvenile record. But we're hoping that this effort will help make sure that the information is more attainable. If you guys all had to go look into every single state statute on record clearance, I would, it would be very daunting. Some states, as an example, I gave you Missouri, which was very simple, but some states have very confusing and complicated ways and processes in regards to record clearance. And the website does its best, and we've tried to maintain it in a way that can help people even understand that process. We've had state experts who have reviewed some of the materials and have given us feedback to make sure that what we have is accurate. Our goal is to always make sure that it's accurate and that it's updated. So in 2018, we're going to keep up with the legislation and any changes in the law to know what needs to get updated for the next round. And finally, last question, what are some of the best ways you have found to address the educational issues? There needs to be more educational advocates. So many times if a young person has to go through the process alone, it's very daunting and overwhelming. That it's been quite successful to have attorneys involved in the process, but you don't have to be an attorney to be an educational advocate. Sometimes the school, sometimes different actors might respond differently to an attorney than they would someone else, but you do not need to be an attorney. You could be anyone who has been assigned through the parent as the education rights holder to help advocate on behalf of the young person, to make sure that they are following proper procedures and rules related to any suspensions or expulsions, and that the young person is getting the opportunity to fully access their educational opportunities. And in regards to special education, there's usually many organizations in every state that provide assistance for advocacy in regards to special education needs. The schools have a requirement, what's called a child find requirement, to actually determine who is in need of special education services. And special education services are supposed to be in the least restrictive environment possible. So that doesn't mean that just because a young person has some special education needs that that young person is supposed to be removed from the regular classroom. Actually, it's the opposite. as much as possible, the young person is supposed to remain in their classroom so that they are getting the same education and treated the same as other young people in schools so that they don't feel ostracized from the rest of their classmates. I would love to talk with you all more individually. Please feel free to send me emails with questions. I greatly appreciate the opportunity to share with you all, and I hope that this information has been helpful. If there's information about your specific state that you have questions, I'd love to talk with you about that and look forward to hearing from you in the future. Thank you.